Welcome to Miami, everyone. This is the panel on the rent regulations in New York, and we have a nice spectrum of guests here who have experience in New York and then also experience in other parts of the country. And if you look at what's going to happen in the future, I think both of these two issues from being only New York are going to meld with what's happening in the rest of the country. And so there's a lot of good content that we will share with you here today, and hopefully we can shed some light on some of the positive things that you can do to take action in light of the law and what to go from there. So I'm going to take one moment and just introduce our guests. So first we have Rob Thomas. He's the director of Damon, Leong, Kupchak, and Hastert, and he focuses on regulatory takings, eminent domain, and property rights cases. He also has one of the most widely read blogs on this subject. Welcome, Rob.
Thank you.
And then directly to my right, Jim Burling. He's the VP of Legal Policy at the Pacific Legal Foundation. And I got a kick out of this. I'm going to actually read parts of Jim's bio because it was entertaining enough that I think we should read it. Before becoming an attorney, Mr. Burling had been a productive member of society, working as an exploration geologist in the late 1970s throughout the Southwest U.S. However, after several years of dealing with irrational government bureaucrats and environmental policies untethered from reality, Mr. Burling decided that what the world needs most is another lawyer, if they were willing to fight for rationality in regulatory regimes, property rights, and liberty. When Mr. Burling is not suing the government, he enjoys skiing faster than he should, biking, hiking, swimming, reading, and spending quality time with his wife, family, and grandchild. So thank you, Jim, for that. That gave me a laugh, and welcome. And then next, someone, for all the New Yorkers in the room that we all probably know, Kara Rakowski, who's a partner at Belkin. And welcome. You have a few applause there. That's allowed here. And you're the co-chair of the firm's administrative law department, and all other good things, New York City. And finally, Kevin King, who's a partner at Covington Burling. He advises clients on appellate litigation, administrative law, and communication matters. And you've argued 9 cases in the federal courts of appeals, which I think is particularly useful given what's happening today. So welcome, Kevin. And I thought we could start off, because we have such a diverse background between all of you, is the main theme here is individual owners or investors or private U.S. citizens in some form taking on the overreach of government. And you guys have all had experiences where you've had wins in that category. And maybe could you just give us a quick synopsis coming down the line of what one of those wins were, so people have a background of the type of experience you have.
So, Peter, would you like me to start?
Yeah, why don't you start?
All right, I'll start. Our claim to fame is a U.S. Supreme Court case called Kaiser Aetna against the United States, in which we successfully beat back a U.S. government attempt to force a private marina owner to open up their marina to public navigation. So, among the lawyers, it's a well-known case, and that's our claim to fame.
Good morning, everyone. I'm Kevin King, and as Peter said, a partner at Covington Burling in Washington, D.C. My most recent victory of this sort against the government is a win last year in the Supreme Court of the United States against the U.S. Department of Justice and the Postal Service. They had sought for a very long time to invalidate a small business's patent, and we were able to overturn that campaign and reinstate the patent. It's an example of a broader theme of my practice, which is pushing back on government overreach and standing up for constitutional rights. And as we'll talk about today, that's part of why all of you are here, and that's why I'm here.
Great, thank you.
And I'm Kara Rakowski, and I will tell you I represent owners of rent-regulated property in New York City. So as far as recent wins, I wish I could tell you that we've had recent wins, but anyone who's familiar with what is happening in New York, you know, there are none at this point. We are working towards challenging the new rent laws and chipping away at various aspects. There is large litigation that is currently pending on the federal level with various groups that represent owners who have come together and have hired counsel, and we have commenced suit. But that's going to take some time, and we're in the process of chipping away, though, on a daily basis, the various changes in rent regulation and representing owners and advising them, what do you do now what can you do going forward while we wait for this litigation to resolve?
Great, thank you.
And my name is Jim Burling. Pacific Legal Foundation has had about a dozen victories at the U.S. Supreme Court. My favorites are one where we just last June won a case where we defended the right of a woman to sue for a regulatory taking in federal court. For many years, you could not go into federal court with a regulatory takings case. We won that one. But my all-time favorite has to be the one that I argued at the Supreme Court. It was where I represented Anthony Palazzolo, who had 18 acres of wetland in Rhode Island. He could not develop it, and this Rhode Island courts told him he could not sue for a regulatory taking because he acquired the property after regulations were put in place. He, in fact, acquired it from himself. And we won that case. Justice Kennedy wrote that future generations, just like the present ones, have the right to sue for a regulatory taking. And my favorite part of that case is the attorney I argued against was then Attorney General Sheldon Whitehouse. So I beat him once, and we can beat him again.
All right, that's great. Yeah, thank you. And I want to mention before I forget that when we were preparing for this, Jim sent me a PDF that's about 25 pages, which is the beginnings of some work that you're putting together to summarize the issue of rent control across the country. And I don't know but if you could make parts of that available to people in the audience, I found it very interesting and really summarizes what's happening here and also how it all works together. So
I'd be happy to. Just let me know how I can get that out.
Okay, so just putting that out there. Kevin, maybe you can start us off. People have remarked that the New York City legislation is one of the most overreaching pieces of rent regulation legislation ever to be passed. Would you agree with that? And how do you grapple with that with a little bit of the background?
Yeah, Peter, I think those aren't my words. Those are the words of the folks who sponsored the 2019 amendments to New York's rent stabilization law, that they're the most aggressive, far-reaching tenant protections in the nation's history. And indeed they are. And they go so far that, as Kara was talking about, we believe they go too far in constitutional terms. There's nothing else like them anywhere else in the United States, and I think that's one of the main reasons why you're seeing pushback in the courts, Peter.
What are the aspects of the law that the counter case put forth by CHIP and RSA that you think have some merit to them or have some real legs? Maybe could you talk a little bit about the different aspects of the case and what they're hitting legally?
Yeah, and I think, Kara, you should jump in on this too, since you're involved in that litigation. I am as well, although less directly, in that particular suit, right? One of the things that's going on in that suit is a claim that there's a physical taking, that when you put together all the different pieces of the 2019 amendments to New York's rent stabilization law, and many of you in the audience are familiar with this, some of you may not be, but when you put together elements like you can't really get in there and occupy your own apartments for personal use, even as a primary residence, right? Or if you can, it's at most one unit. And you put that together with the lease renewal and successorship provisions that basically say that when a tenant ends, it can go on in perpetuity across generations for potentially hundreds of years. And you put that together with the limits on major capital improvements and IAIs and other things like that. And what you have is essentially the government taking core property rights away from the property owner and giving them in the form of a transferable rent-regulated life estate to the tenant. And I think that's, when you look at Supreme Court doctrine, that's one of the most powerful claims.
Rob and Jim, from a U.S. perspective, do you guys have any comments on the power of the legality of those arguments?
The idea of a regulatory takings is fairly old. It's something that is a very powerful tool for keeping regulations in check. However, it's been very difficult over the years to get courts to agree to that. Courts are very much wrapped up in the idea that property and everything can be regulated to a great extent. But when that regulation goes too far, when it denies economically viable use of property, if it causes a physical invasion of property, it is susceptible to challenge. And I think we are at a time in our history where the idea that a person can go to court to challenge a regulation based on the doctrine of regulatory takings is getting increasingly strong. We have a Supreme Court that seems to be very susceptible and receptive to those arguments. It's a long shot. You try to bring this case in New York state courts or the lower courts, it's going to be tough. So I think what these folks with the chip are looking for is taking this thing all the way up to the U.S. Supreme Court. And if not this one, another case somewhere else, because rent control is happening elsewhere, as you know.
So what I heard you say is that in a way this has got to get to the federal level if it has any legs on it.
Yeah, and they filed this in federal district court, and it's going to go up to the Court of Appeals fairly soon, and the hope is to get it up to the United States Supreme Court.
Rob, were you?
We take the temperature of the country in New York City, and that's true both politically and legally, right? So the rest of us out, west of the Hudson are watching these cases and this sort of regulation with a very close eye for a couple of reasons. First of all, because the law is politics by other means sometimes, and we start seeing similar types of regulations being enacted and adopted around the country. Most notably California, Oregon, and a lot of municipalities are picking this up. So how goes New York, so goes elsewhere. Two, when it starts to look like your property doesn't look like your property anymore and you don't own the apartment and the right to receive rents, but essentially you are the caretaker of public housing, that's when it starts looking like a taking and a problem for the courts. Where that line is always been a difficult question, but there's been a few cases over the years successfully argued by the likes of Jim and Steve or Kevin that establish that. So all of us in the rest of the country are watching this series of litigations, both the one that's ongoing now and the one that's going to come up soon, for how these go. So this is incredibly important, this session, and how this series of cases works out.
Yeah, well, I'm glad you bring that up because that is one of the questions that everyone has. Well, will this win? And we have two of the attorneys who have won cases similar to this on the panel right now, and so just wanted to make that point. Kara, what you wanted to jump in?
What is different about this litigation that we commenced now is that the statute that was passed in New York in June it eliminates the sunset provision that was under the old code. The sunset provision, basically every few years, rent regulation came up for renewal. So we had an opportunity to challenge every few years, to make changes, to challenge it. What New York State did was they eliminated the sunset provision. So the argument for a regulatory taking is definitely much stronger now, being that that was eliminated. The other thing is that they also declared a permanent housing emergency in New York. That also goes towards our argument for regulatory taking. Rent regulation in New York first came to be after World War II. There was a housing shortage in the 40s. Rent control was passed, and there was a finding that there was a housing shortage and their tenants needed protection. Over the years, that housing shortage has dissipated. It has been eliminated, and yet it keeps getting renewed, now through rent stabilization. But the fact that they've eliminated the sunset provision and found a permanent housing shortage definitely makes the case stronger.
Part of this, I think, I've said this before, but when this law came out, about 3 weeks later, we sent a survey out, and we surveyed 18,000 multifamily owners in New York City, essentially all the New York City multifamily owners. And we asked them a question. We said, was the law that passed the same as what you expected, worse, or much, much worse? And essentially 90% of the people who responded said that the law was much worse than what they expected. There was a real surprise element to it. We knew it was going to get bad. We didn't know it was going to get this bad. Something that I think that's about to repeat itself is people aren't aware that in January, the good cause eviction law will probably also get passed, which will essentially be universal rent control in New York City. Can anyone on the panel speak to kind of the next phase of this that we think is going to get passed in January? Either Kevin, Kara, or
We were actually discussing this at a CHIP event last week. There is significant push for the good cause eviction to be passed. There is significant opposition also. We don't know where it's going to fall out, and we don't know exactly what provisions are actually going to be passed. But we do expect that there are aspects of what is happening in New York that are going to be getting worse before they get better. Because New York hasn't yet seen, at least not outside of people in this room, I'm talking outside the real estate industry, people haven't really seen the effects yet of this statute. People in this room have. And the industries that rely on the real estate industry, for example, contractors, immediately contractors were down 70 to 90% in their business, immediate. That hasn't affected the rest of New York's economy yet. So we'll see that. I know what they're talking about is a law that's very similar to, I believe, what California has as far as good cause eviction. So we have to wait and see.
Yeah, either Kevin or Jim, how do you think that impacts the national conversation if now, 6 months later, New York also passes universal rent control, essentially via this good cause eviction?
I think there's this tide sweeping the country, maybe a red tide sweeping the country, just not off the Florida coast anymore, where what happens in New York, you want to emulate that in Oregon and Washington State and California. So in all of these jurisdictions, there's either brand new rent controls that have been passed in Oregon that look kind of mild right now. California passed one that said you can increase rents 5% plus CPI or 10%, whichever is less. But these are only temporary. These are just the starts of what we're seeing in California. And I think a lot of people are looking to New York to see what you can get away with. If you can get away with this in New York, we're going to try something further in California. There's a push in Chicago and Massachusetts and Washington State to undo rent control there as well. I think we're looking at a serious problem nationwide because the idea of rent control used to be an anathema in most of the country. But now it is something that's seriously be considered and passed, and I think that a good part of the country is in for trouble if you're not able to stop this in New York.
What happens in New York doesn't stay in New York? Is that really the bottom line? It's the opposite of Las Vegas?
It's like a sewer treatment plant where everything goes downhill, and you're in the top.
Well, I think it's interesting that you bring that up because the multifamily space, over the past 10 years, since the bottom of the last recession, we're now 10 years out from that, the multifamily space nationally has been one of the best asset classes to invest in. And the reason why is precisely because the supply and demand fundamentals were out of whack, in that nationally we have a housing shortage. And we were talking for a few minutes before they turned the mics on, that if you started now building new supply in these areas of the country that need it, it would take almost 10 years to deliver it all. And so it's causing these societal stresses that get all mixed up with politics and housing policy and all that type of stuff, which is causing this. But I have read and happen to agree that the way you resolve these issues are by massively increasing supply and encouraging low-income home ownership. What do you guys, Kevin or Rob, how do you respond to that?
Yeah, I mean, right, the law of supply and demand, more so than the law. The fundamental economics tell you that the reason for high costs are a shortage of supply. And yet, in almost every jurisdiction that you see rent control coming out of as a solution, on the other side of that, there's also highly restrictive barriers to entry to creating new housing. There's a little bit of light in some places, what they call instead of the NIMBY movement, the YIMBY movement, yes in my backyard, please build more dense infill type housing. But I don't think is that too late, too early, or where is that? We don't know. But the solution, it's incredible to me, given our experience with this, that often the solution is price controls as the solution, which the economists are pretty universal in telling us that, well, that will just create more shortages and less quality, as people will be unwilling to enter the market or will get out of the market entirely. And so where this becomes the legal problem is when the laws that you see either forcing people, the owners, into the rental market by not being able to determine who their tenants are in some cases, or once you're in the market, not being allowed the free exit from the market that your checkbook would dictate normally. If it doesn't make sense, you can get out. A lot of these restrictions are coming in, says, well, once you're in, and you can't leave. It's kind of like the mafia, right? There's no exit from the market once you're in. And I think those are where it's really problematic when the solution, all the economists say, is to increase supply. And yet, for whatever reason, we're not, at least in fits and starts, are not willing to do that.
Kevin, what do you, the question is, what can owners do? What can they do? They're sitting there, this is something that happened to them. What can they do about it?
I'm glad you asked about that. A lot of you in the room are involved with RSA and CHIP, or organizations who already are litigating one case in federal court that we've talked about today, and that's a really good first step. Those are great organizations. But there are additional things that you can do if you're not involved with them, or even if you are. Stephen, at the very beginning of this panel, discussed RNY and the effort it's putting together to bring together landlords, property owners, large and small, to make a difference, and to make a difference including in litigation. And to that end, RNY has been coordinating on a new lawsuit that will be filed, indeed as soon as this week, in New York Federal District Court, that will broaden the playing field with respect to these challenges to New York's rent stabilization laws as they were amended this summer. And you can get involved in that. All of you could get involved in that.
Do you think the counter push is improved by having multiple lawsuits occur at the same time?
It is. It's more ways to win, Peter. The existing lawsuit by RSA and CHIP is very strong. It brings one particular class of claims. This additional litigation will broaden the playing field by bringing additional claims and coming up with more ways for us to get to a solution here. And being part of that litigation, being one of the plaintiffs or being involved behind the scenes, either way, it gives you a seat at the negotiating table to stand up for these property rights and to be part of fashioning a solution.
Great.
And that's going to be a long-term process, as Kara said.
Great. Kara, can you give us a story that will show an example of the difference that you see in housing court between taking someone on a legitimate case to housing court today versus 8 years ago in New York City?
Well, I could tell you that now, with the change in the new law, the process is going to take even longer. I mean, New York was never quick when it came to a housing case.
So what was it 8 years ago? If you had a slam dunk case, what was it?
It depends on the case, but for example, non-primary residence case, 18 months.
Today, what is it?
Today, non-primary residence case, you could expect 2+ years, easy. Tenants now have the ability, even if you have a warrant of eviction, they have the ability to allege that they do not have a comparable place to move to, and can delay the eviction for a year. And it's totally within the housing court judge's discretion. So there's a lot more, there are a lot more tenant favorable provisions that were added. All of the notice requirements have been extended. There's no longer, for a non-payment, there's no longer a 3-day notice. It's now a 10-day or a 14-day notice. There is a prerequisite. If a tenant has not paid their rent on time, after the 5th of the month, you must serve an additional notice on them, which is basically a letter saying, I haven't received your rent. And then you can then serve them.
I think I'm going to sell my house and just rent for free.
Listen, the bottom line is for owners, in the beginning, what we saw after June 14th, because it was a lot worse than what all of us expected. Example, treble damages on overcharges at the State Division of Housing. We had no prior notice that they were going to extend it to 6 years.
Yeah,
Previously, it was 2 years. That's a huge difference in liability. So there were many of those changes that we did not expect.
Well, that's one thing that comes up in conversation is we all know what the headlines of the law did in terms of a lot of the top 4 or 5 business changes. But there's another 50 that are little things like that you're
Absolutely.
mentioning right now that actually, when they play out, have a big impact on how you operate these buildings. We're seeing it come up in operating, in our underwriting. How you underwrite operating costs is what do you put in for the category of general and administrative, because some of these things can come upon you and hit a building, and it could be $40,000. The next year it could be zero. The year after that it could be $50,000. There's no way to kind of gauge this. Jim, what impact do you think this issue plays on the election that's coming up?
We have some of our national candidates who have proposals for national rent control. I mean, and these things are very scary. If you look at the proposal that Bernie Sanders has to have a rent cap of 3% or 1.5 times CPI, whichever is greater, I mean, it's the first step in the door. So you have Congress coming up with national legislation like this, or AOC has her own. But the problem is, like in New York, it looks fairly simple. 3% plus CPI, that's terrible, but you can maybe live with it, maybe not. But what's really going to be passed, nobody knows. And as the folks in New York went crazy and adding all these things to what nobody expected to happen, the same thing could happen nationally. Because when you have various states, as I said before, like Massachusetts, people in Chicago want to get the ban on rent control there overturned. Washington State, there's a ban on rent control there, but the mayor of Seattle, who is just reelected, says this has got to be our goal to stop greed and capitalism from landlords. That's her words, to get rent control passed. So it's a nationwide problem, and I think that's something that people outside of New York City cannot sit by complacently and think, hey, this is somebody else's problem, because if it's not your problem now, it can very well be your problem later.
So something that I think will be helpful to people in the audience, if you're in New York, you're hearing about this subject every day, it's part of your world, you talk about it every day, all that kind of stuff. What is the temperature of this subject nationally when for example, when the candidates put this out, is that going to seriously help them, or what's the temperature? Where is your, because you're in this world, where is your opinion of where public opinion is on this subject?
So, the progressive wave is very strong right now. I don't think we have seen a greater push for rent control since the 1970s, where a series of cities in California adopted rent control. And there was some pushback after that for quite a few years. But I think we've come full circle. Rent control is something that is staring down people's faces in a lot of cities, a lot of states that are now becoming more progressive. And if you have a progressive push in your state, you're going to be looking at rent control one form or another very soon if you're not looking at it already.
Kevin, please.
The nationalization of these issues in legislatures and in city halls is one reason to nationalize the other side, for property owners to organize and to get together and to get into the courts in places like the Courts of Appeals and the U.S. Supreme Court, which have national or at least regional reach, to come back and to fight back, right? And so that's part of the plan for the litigation here, is to not just stay in New York, but to develop precedent that could apply nationwide. And that's part of what we're working on, and that's part of what CARE is working on.
And we're looking at cases in other states to perhaps bring as well, because if we have different circuits, federal circuits with different decisions, that helps to get one of them up to the U.S. Supreme Court, which is where I think, as I said earlier, we're going to find relief.
What do you think are the next, if you had to predict, the next 2 or 3 states that will enact this? I mean, you saw New York, California, Oregon. What are the next 2 or 3 that you think are
I think there's
most
a
susceptible?
serious push in Washington State right now to overturn the prohibition on rent control. I think there's a serious push in Massachusetts. There are a couple bills right there now. One is for elderly tenants over 75 years to give them greater protections, but right behind that is a bill to just get rid of the prohibition on rent control in Massachusetts. You may recall that a number of years ago that Cambridge, Boston, and one other city in Massachusetts had rent control. The folks in Cambridge thought, we can't get rid of this on a local basis, so they went statewide with a referendum, got rid of rent control, but it looks like it's trying to come back right now. So folks in Massachusetts should be very concerned, because the politics have changed. And if it does change, there could be rent control
Didn't
again.
all the economists who said it was bad come from Harvard, which is in Cambridge?
Yeah, exactly. There was a study comparing what happened in Cambridge before, when they had rent control versus when rent control was removed. And at one point $2.4 billion in increased property values in Massachusetts occurred. There's been a building boom of people to build more family housing and multifamily housing. All these good things came out of the repeal in Massachusetts, and yet we're looking at the return.
Yeah, and when I was in college, I lived in one of those units, but
I think where we have failed in New York, which needs to be considered on a national basis, is that whenever there's the discussion about rent regulation, it's always, and this has been interpreted this way by politicians, by tenant advocates, it's always the tenants who need protection, the poor, underprivileged tenants who are the working class people who need to be protected. Rent regulation, at least in New York, there is no means test, right? So, and this is where I think we have failed because we don't publicize this enough. And that's why each time I speak at an event, I bring it up. Because what we hear from, and I've had politicians sit down and negotiate with me various aspects of different laws, and it always comes up, and then I have to explain to them, there is no means test. So whether you are making $10 million a year or you're a public assistance with no income at all, you are entitled to occupy rent-regulated property. And that's where I think the system fails, because private owners should not have to subsidize people who could afford to occupy and pay for their units. And if you are going to have to subsidize the affordable aspect of it, then you have to incentivize owners to do that with tax incentives, for example.
well, every now and then the New York Post comes out with an article of like some famous person's daughter or something who lives in one of these apartments, and you kind of chuckle at it. But Rob, I saw you, to some of these statements, I saw you nodding your head and jotting notes down.
Yeah, very much so.
What was happening in that head?
Two things. You're up against an opponent with unlimited money, power, time, and PR through the bully pulpit, and I'm talking about the government, right? They don't pay their lawyers the exorbitant fees that we charge. And they have that vibe, right? We are there, you make enough vibe, the greedy landlord's vibe that plays very well these days, right? In the national and on the local scene.
Are you saying that they take a stance of moral authority, which gives them license to do whatever they want?
Yes, I mean you see it all the time, right? I mean, saying that ironically, the lawsuits that have been filed saying that these are a taking or something else, those are eroding the protections of people like Faye Dunaway, right? Who I think was the one I read most recently. Like, she needs a rent-controlled apartment, and this is a clarion call. I think the New York case is particularly because if there's not pushback there, you haven't seen the bottom yet. Because this means you would think, despite a very aggressive rent control regulation now in New York, that maybe that's the last of it. Well, no, that simply, unless there is aggressive pushback, experience tells us that this is simply the first step to even more. So, again, those of us in the rest of the country are watching, but also you have not seen the bottom yet, unless I think one of these lawsuits, one or more of them, catches the attention of the courts or the regulatory side of things. So I think they're very important for that reason. And so that's I wrote down here, money, power, time, and PR is the opponent of this thing. Yeah.
Another thing that we asked, I mentioned that survey that we took, is we asked owners, what are you going to do now when you get a vacant apartment in New York City? And about 35% of them said we're going to leave it vacant. Kara, how are you advising your clients on this issue?
So one of the issues that we believe is going to be revisited by the legislature, because since there's no sunset provision, they can look at it anytime they meet, is potentially putting restrictions on warehousing. Years ago, there was a case where the city did they did pass a statute prohibiting warehousing. It was a case that involved a single-room occupancy building. It went all the way up to the federal level, and it was determined that the statute that had been passed, the anti-warehousing statute that had been passed at the time, was unconstitutional. So I think they will have a more difficult time with, passing or at least implementing a new statute regarding anti-warehousing, but we do expect something along those lines.
They're going to try to.
They're going to try.
Yeah.
And the thing is that most owners that this isn't, I can't say most owners, this is a very common issue for owners.
Yeah.
And I've had people tell me, I just received a rent stabilized unit back. The legal rent is $650 a month. It needs to be put in, it needs to be renovated to get this back on the market because the tenant has been there for years. What am I getting? I'm getting $83 or $88 a month.
Yeah, you can't pay for the renovation.
Right.
Yeah.
I can't pay for the renovation, and I'm maxed out at $15,000 now
Right.
over a 15-year period. I would rather leave it vacant or rent it to a family member.
Right. Yeah.
So if I could follow up on that, a rather dangerous idea that has gotten an increasing amount of buzz is a vacancy tax for a unit that is not developed or is not rented out, or in some cases a lot that hasn't developed. The idea is to put a tax on that so it will hurt to keep it vacant. That's something you got to watch out for as well.
Yeah. Well, yeah. I was at I was doing a panel last week, and we were talking about other investment options, and in preparation for it, I was looking at some of the articles that Ray Dalio had written about investing advice, and for those of you who don't know, he runs one of the most successful hedge funds ever to be around, and there were two things that he mentioned that I think were relevant, but one of them was that diversification is one of the most important aspects of any investor's strategy. So, that's kind of what you. Go ahead, Kara.
I just want to also mention that there's currently under New York law, there are a couple of options that are available to owners that have vacant units, especially if you get adjacent vacant units or one on top. So we do believe that that's going to be revisited because that's a very hot topic now. Sub-rehab of buildings that are at least 80% vacant, that's also a hot topic. We're doing a lot of work in those areas. There are things available. You just need to be able to think rationally and act quickly.
Now, part of what I'm hearing in the market is that there's a little bit of a contrarian movement here happening, which is 12 or 18 months ago, if you were buying a rent-stabilized building in New York City, on average, the cap rate was about 3.5. We've signed contracts on almost 30 buildings since June. And so now we have that cap rate data, and the average cap rate is about a 5.25 now in New York City. So you have almost a 200 basis point increase in cap rates since the law has passed. Now, a contrarian investor would look at that and say, last year was the riskiest time to invest because we didn't know what the law was. Now we know what the law is, and buildings are actually 40% cheaper, so we should be investing now. Kara, Rob, Kevin, does anyone want to comment on this?
So I will tell you that, and this is a question that comes up all the time, we are really busy on doing due diligence projects and reviewing for purchases. So yes, there definitely is a difference in the cap rate. There are people taking advantage of that difference.
Yeah. Although the number of purchases is way down. It's down
Correct.
like 80%. But
I would say to your point about knowing what the law is, that's true in one sense. You know what the legislature wants the law to be, but I think there is some lurking uncertainty from these litigations that we're working on that the law could come back the other way. And I'm not an investment guy. I'm a litigator. I handle appeals and constitutional litigation, so I can't speak to the business side of this, but what I can say is if you're that contrarian investor, maybe you're taking that potential counterswing into account.
yeah, I mean, most of those business plans are shared with me, most of them have a 10-year outlook upon them. So at least,
And just to that end, there's a lot of pessimism and gloom going on here, but I think there's at least a little glimmer of optimism, especially at the U.S. Supreme Court. We've got a new justice there, Justice Kavanaugh, who replaced Justice Kennedy. Justice Kennedy, as Rob and Jim and everyone else knows, not a great friend of property owners when it comes to takings. Justice Kennedy, right? His successor, Justice Kavanaugh, thought to be much stronger on that. And so that one justice change at the Supreme Court could produce a revolution in property rights. And if President Trump gets another Supreme Court nominee, then the game really could change.
Yeah, if you get there.
If you get there.
If you get there.
So it's uncertain.
Yeah. What's it like preparing for one of those cases? At the top level?
Yeah. When you're preparing for a case at the Supreme Court, your entirety of your life revolves around that case. I think I had kids at that time, before and after, but I'm not sure right then if I still had them. I know I didn't have my wife at that time. She said, I haven't seen you for weeks. When you go up to the Supreme Court, you are as focused as you ever can be, and a little bit nervous, extremely nervous, because these are the big nine. But I tell you, once you start arguing a case before the Supreme Court and you're prepared, it's as much fun as a litigator as you can possibly have, because you know all the facts, all the cases, all the issues, but you also know that you're litigating for a just cause, which really helps. And just to try to convey that to the court and knowing that you're breaking through to some of them is a great feeling.
Yeah. How, when you said just cause, I've this phrase, if you name the game, you own the game, and I think the use of good cause eviction as opposed to universal rent control is a political kung fu move, because the general public has no idea what good cause eviction means. Universal rent control, everybody knows what it means. So when you said that, you threw me off there. Was there a particular judge that stands out in your mind as for any reason?
Well, everybody loved Justice Scalia, because sometimes I would get hit a question and I would answer the question from another justice, and the justice kept on pounding me. Justice Scalia would jump in with a quick retort, answer the question, and let's move on, essentially is what he said. He had a brilliant, quick mind. The court, when they ask you questions, they're really not so much trying to get an answer from you, but they're debating with one another. And when that begins to happen, when Justice Scalia would move in with a response, basically taking over the debate, it's a great feeling to know that Justice Scalia is on your side in a case like that.
How do they ingest so much information to prepare? How do you do it?
How do they do it, or I do it?
How do they do it?
They have law clerks. They have lots of very brilliant law clerks. I think some of them former law clerks are up on the panel up here.
I was one of those clerks for Justice Scalia, and it's late nights and weekends and all the rest. But yeah, they spend an inordinate amount of time preparing and getting ready for everything.
So were you doing the reading and prepping and then briefing him? Was he doing all of the reading? Was he outsourcing some of it to you? What are the mechanics underneath the surface?
In his later years, Justice Scalia was a little bit of a slacker, and he relied a little bit more on his clerks, more than he had earlier in life. But he still worked very hard, and he would do his own reading. He would read the briefs, he would read the facts, the lower court's opinion, and we would have a discussion. And each justice has 4 law clerks, and they'd go in, and he would expect that this would be a live fire, essentially combat without exchanging blows. He wanted to have an aggressive discussion about the issues and play devil's advocate, and it's through that he got ready.
Yeah. Well, that's great. It's great to hear those stories. So we have a few minutes. I'm going to wrap us up with a few speed round questions, but before I do, we have the ability to offer the attendees the opportunity to ask everyone some questions here. So do we have any from the audience?
The issue of PR to me, people keep talking about it, but I don't see anybody doing about it. When you're talking about 18,000 owners, if each owner gave $10,000, that's $180 million. We should, we as an industry have failed, and I think we failed because we targeted the wrong audience. We targeted the politicians. People say they're idiots. They're not idiots. They just say what they believe what their constituents want to hear. And if we went to the right target and did it in the right way and explained to them, whether it be the test that you're talking about, or the partner at Weil Gotshal that's making $5 million a year and has a $10 million house in the Hamptons and lives in a rent-stabilized apartment, and went after the right target. One of the smartest people that I know is a dear friend of mine once coined the phrase, the difference between perception and reality is you can change reality. So the question is, how do we change perception? But by just saying we should do it and nobody doing anything about it, whether it be RNY or CHIP or REBNY or whomever, we need to do something so that the public will understand what is happening and how they're going to get hurt. And again, if the policeman and the fireman and the EMT worker wants to live in a rain-stabilized apartment, God bless them. Let them be there. But, whether there be the movie star or the partner in the, Fifth Avenue law firm or whatever, they don't need to be there. And the building's falling. I don't have to make the speech. We all know what the issues are. But there's things that we can target. They should be on TV every day. They should be in the newspaper every day, even on CNN every day. Let them make a couple of bucks, not that I'm wishing it on them, but so that audience will start to understand, and you say to them, please tell your politician to not do something stupid because I don't want my building falling apart.
Yeah.
I agree 100%. You're right, it's finding the right target. Definitely in this last round, originally when we were lobbying, we sent busloads of small owners up to Albany. Politicians would not even meet with them. Then later in the game, we started sending busloads of contractors to Albany. We got some audiences, you know what I mean? But it was, I believe, a little bit too late in the game. I think that's determining who we target and to have rational conversations with these people to make it clear that this is a real issue and it's not just the big owner. I think that is crucial going forward.
Well, and Avi, if, I think about this, I've made this comment at the CHIP meetings myself, is that the response has to be digital. I mean, the fact that I can get information from 18,000 owners, but, how many of us are showing up at Julia Salazar's, any of her events or anything like that. So it's really not that many people. There's a lot more firepower, even in this room. Jim, I have a question for you relative to this. We're in his hotel. Has President Trump been good or bad for this issue?
Oh, that is a loaded question.
Yeah.
President Trump has been very good in terms of who he has appointed to the federal judiciary. We have, between what the Senate and the president has done, we have probably the best judiciary we could possibly have hoped for at this point in our history and at this point in our time, which gives us hope that lawsuits like these actually have some potential of winning. What President Trump has done on other regulatory rollback has been fine, although that's all mired in the courts because he hasn't appointed all of the judges yet. So there is a lot of litigation trying to stop his regulatory reforms and rollbacks.
And Peter, let me just jump in to make that concrete. For those of you who are in New York, Connecticut, the Second Circuit is the federal appeals court that covers those states. When President Trump started his term, it was by far majority Democrat appointees who took a very government-friendly approach to property rights. Now, today, it's a majority Republican appointees because of the efforts of President Trump and his team. And that's going to be an audience of judges who are going to be much more receptive to the kinds of arguments we're making. Does that guarantee us a win? No. Does it give us a better chance of prevailing? Yes.
First, just to comment, I think the fact that the idea that we're subsidizing the wealthy people is really, we should not be subsidizing anybody. The government, if the government feels they should subsidize low-income tenant, they should subsidize it. It should not be the burden of the building owners, just a comment. But on the PR side, I think we are wasting our time. I've met with a number of state senators, and they basically, the story was, these are the same politicians which chased away Amazon, and they told us, you guys had 20 good years, you made all the money, we don't care. It's basically a vendetta. They don't like people who have money. And it's a fact. So that leads me to the question to you, Kevin. Our hope, really our real and sole hope, is the Supreme Court of the United States. And as much as there's a possibility that President Trump might appoint another judge, there's also a strong possibility they might not be reelected. And who knows what happens, and when the case eventually gets there, it will really depend on the makeup of the Supreme Court justices, right? So my question is really, there is already a case pending. And that case is an official case, and it's making I believe the answer was already provided by the state, and the organization are putting in an answer in a couple of weeks. And that could be already at the appeal level sometimes in the middle of 2020. Starting a new lawsuit runs the strong risk that the state is going to ask to consolidate the cases, And part of your case, I understand, is not just a facial case, but it's on facts. It depends, and it might involve discovery and delay the whole thing by who knows how long, and bring it to the Supreme Court who knows how much later. And aren't you really jeopardizing our chances to the Supreme Court by doing that, and not by joining or trying to consolidate and do it together?
I'm really glad you asked that, and I think speed is critically important, as you say, right? One of the ideas here, we talked earlier, Peter, about uncertainty. One of the uncertainties is uncertainty over time. That's really what you're highlighting here. We do not want to contribute to that uncertainty. On the contrary, we want to increase the odds of success. And I think any delay that would result from a new lawsuit would be maybe 2, 3, 4 weeks at most, not much time. But what would it do? What would it add, right? It would add a tremendous additional layer of potential claims that can prevail. And those claims, the way we look at it, would not slow things down materially. So when you net out the costs and the benefits, to us, it's a slam dunk, easy answer. The benefits outweigh the costs of broadening the playing field here and in bringing in more folks.
Rob, did you have something to add there?
And my colleague on the public interest side, Jim, could probably add some things here too. But what I think is critically important in these things is when you've got that issue, is not to do a kind of a one-front attack. There's law, economics, PR, politics. On the law side, I've always, the more full court press you go on all of the issues, and not put your issues into one case or one issue within certain cases. Now, there's a very famous rent control case from my home jurisdiction that they narrowed the case in order to get it up to the Supreme Court, where they lost 8-0. So that, to me, was an illustration where they made, I thought, a good tactical decision at the time, but it didn't pan out. I always thought that they would have had a better chance if they'd have broadened the scope of their claims and taken some other claims, but they were interested in a particular legal issue, and that's what happened.
Well,
so
that's really telling. I'm sorry to interrupt, but didn't the Supreme Court say in that opinion that, hey, we wish you'd brought this other claim, but it's not here, so we can't help you on that, right?
In fact, they asked the advocate, are you are claiming argument A, is that correct? Yes, Your Honor. What about argument B? Are you making argument B because I, as a judge, actually think argument B is a pretty good argument? Your Honor, specifically, we are not raising argument B. And guess what? They lost on argument A. And so I always, from a strategic standpoint, in public interest litigation like this, I always think it's better to have a multi-front attack because fighting a two-front war is more difficult than fighting a one-front war for the party that has, unlimited time, money, lawyers, and whatnot.
But to your point, it still means we must go fast.
Yes.
We must hustle.
Never let up.
Jim, go ahead.
Yeah, in the San Remo case, the one that Robert was referring to, Justice O'Connor at that point leaned forward and said, you're not doing argument B? Well, maybe you should have. And that was her remark. But to follow up what Robert is saying, when we bring litigation, we have a full court press. We do videos, we do press conferences, we have dog and pony shows with the clients. We get articles across the country written about our clients showing the sympathetic story of what's happening to them. If you want to win a case of this magnitude, it simply cannot be done in the courts. It has to be done across the way, through the media, through any means you can get to get sympathy for your clients and get the word out, to make the environment comfortable for the court to rule in your favor. If the court doesn't think that it is doing the right thing and it feels uncomfortable about ruling in your favor, it very well may not, even if the law is in your side.
Hi. So we mentioned earlier the anti-warehousing provisions or potential anti-warehousing provisions. So, I wanted to point out potentially that we know the state looks at a regulatory taking lawsuit and they look at what's called parcel as a whole, right? So they say, look, your building still has economically viable uses, so there may not be a regulatory taking. Were they to enact a anti-warehousing provision, they're saying, hey, this particular unit, you have to rent this unit. So now they're breaking down the parcel into the individual units. That can actually be beneficial for us in the lawsuit where the parcel is actually the individual unit, and you have units that have no economically viable use now with rents significantly below market.
It's a possibility, but you also have to remember there's a hardship test, a sound housing test. And that hardship test is a very, very low threshold. It's very different realistically from what it takes to run a building. And I'll give you an example. 8.5% was the amount that the Supreme Court years ago found. It was an 8.5% return on the assessed value of a property. Now, we all know your assessed value is far lower than market value and has no relationship to how much it costs to run an actual building. What was interesting is that one of the owner groups recently did an analysis. They polled their constituents, and they did an analysis across every county in New York City, so not just Manhattan. And they found that on an average, an owner's their return on their value, their return on their investment is about 12%, which is a very interesting number, because when you look how the difference between the 12% that you're earning, right, and the sound housing requirement of 8.5%, that's not a very big spread, right? Considering that you have taxes that go up every year, and sound housing, by the way, in New York State does not include debt service. So that amount really is much closer than we're actually looking at it. Those are the things that we need to get out to the public, to show, because everyone thinks that owners are deep pockets and that you're making a killing on every unit and every building. And it's that type of information that we really need to get out there, is that you're really, on the average owner is really making only a little bit above the hardship threshold.
Yeah. And in many cases below.
Yes.
And in particular, when you're on a per unit basis, if you have that anti-warehousing provision, right? So you're telling me that Unit A, which is renting for $500 a month, and you're saying I have to rent it out. I have to renovate it and rent it out. And that's not economically viable.
Correct.
So.
Correct. And the other thing is that although this is doom and gloom, and I've spent the first 2.5 months, 12, 14 hours on a day on the phone with clients, and every single phone call before I hang up saying I'm sorry for things that I didn't even do, right? Because it was total doom and gloom. People are coming out of that now. Now it's like the grieving process. Now it's like, okay, what do I do going forward? And we have to remember, each step of the way, no matter how small it is, you need to challenge. Whether it's losing a luxury deregulation proceeding, getting an order, because now DHCR has determined that the new code says there's no luxury deregulation proceedings. We're getting orders that are retroactive now. File a par. That's what you can do. Preserve your rights, because if we do prevail in federal court, even if it's 3 years from now, you want to make sure that your rights are preserved. Chip away at different aspects. Don't look at it as a whole, because if you look at it as a whole, it's a losing proposition. Look to see what you can do to make your business better. And there are things that you can do, but you need to preserve your rights.
Well, thanks very much. And I want to, before I just ask the panel one or two quick speed round questions to end, thank you guys for all of you contributing your time and your knowledge. And don't hate me for these last two questions. There's one-word answers. You just got to go down the line and bring them through. So, and we'll start far end coming closer to me, okay?
Sit forward in my chair for this one.
All right. Bloomberg versus Trump next year, who wins?
Trump.
Trump.
One word. That's Trump.
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 Okay, there we go. All right, so that's unanimous. The New York case, succeed or fail, ultimately? Yep.
Oh.
Both.
Win.
Up. Wins.
Oh, yes.
3 words, succeed on appeal.
Yes.
I agree, succeed on appeal.
Succeed on appeal.
At the Supreme Court, if they take the case.
That's great news. Okay, thank you guys, and thank you to all of you.